we're going to move straight on to our next speaker, but it's not Cheryl Howard. Okay, she unfortunately has withdrawn at a very short notice, but we've got just a pretty person as well. So Piet Nel, fortunately, stood in at a very short notice and gladly will take on the session. As you know, Piet is head of the School of Applied Tax. So I think he's well equipped. No, sit down. No, I'm not doing any talking. So he is well knowledgeable about this, and it fits in quite nicely, I think, is what Errol's just been through.
Thanks, Gerald. Yeah. And apologies for being in front of you again. She actually fell and broke her back, so it's quite serious. Now, of course, this was a very last-minute thing. So if you think I'm nervous, come stand here. Initially when we met, and she had some ideas, she had some questions about what she was going to talk about, and we looked at, but how does the Davis Commission and Pravin's suggestions fit into this tax planning scheme? So what I tried to do since last night and this morning, to just say what is the current status of the taxation of trusts in the context of the state planning, and then what are the risks. So right, now we start with Pravin Gordon that said to curtail tax avoidance with trusts, government is proposing several legislative measures. That's where I met Cheryl. We made a submission to Treasury that they don't go ahead with it, and they didn't do that in 2014. Judge Davis, as we all know, said the flat rate of tax should be maintained at existing levels. The deeming provisions of Section 7 and 25 Cap B should be repealed, right, insofar as they relate to South African resident trusts, not looking at the beneficiaries. And this, of course, is not law. This is just proposals, right? The deeming provisions of Section 7 and 25B should be retained insofar as they relate to non-resident trusts, and trusts should be taxed as separate taxpayers. I said, let's just start with a reminder of the history of the development of tax in South Africa to understand the risk and what may change here. Many of the court cases still say that trust law in South Africa is developing. I'll comment back on that shortly. 1984, a tax case, Brown versus Botha, the Judge Hubert said the trust is unknown to Roman Dutch law. It was unknown to the Roman law as well. It were introduced in the 1100s when the English and after the Norman conquest. And he says that our courts have evolved and are still in the process of evolving our own tax law of trust, our law of trust, by adapting the trust idea to the South African context. This was May this year. Judge Lewis, quoting from the BOE case a couple of months earlier, it is clear that in the development of trust law in South Africa, so we are presently still developing trust law. It looks like the Minister and Davis wants to push us on. All right. Now, what was the issue, really, that had brought in an amendment in 1991 in the Trust Act, in the Tax Act? It follows from this question, and you referred to the fact that a trust is not a legal person. In this case, Lupacini versus Minister of Safety, Judge Nugent in the Supreme Court of Appeal, in a unanimous decision, said, a trust that is established by a trustee is not a legal person. It is a legal relationship of a special kind that's described by the authors of Honore's South African Law of Trust is a legal institution which is a person, the trustee subject to public supervision, holds, administers property separately from his or her own for the benefit of another. So this benefit for another, or for the purpose of a charitable other purpose. Judge Cameron, and this is often referred to in trust talks, the Parker case, that really led with how you run your trust. And I don't want to go into that, the Section 33D of the Estate Duty Act and the deeming provisions there. But again, trust estate is a separate entity, but it's, although separate, accumulation of rights, obligations comprise a trust estate, does not have legal personality,